After we start your medical malpractice lawsuit against your careless doctor, can we immediately ask the judge for judgment in your favor without the need for ever having to go through the litigation process and without the need for ever getting to trial? You want to know the answer? Come and join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so here's the scenario. You decide to bring a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. And a medical expert has reviewed your records and confirms that yes, you have a valid basis for a case. So now you know in your heart of hearts that you have an excellent case, not just a good case, not just a great case, but an excellent case. And you know that the judge who evaluates your case is going to go ahead and agree with you 100%. You know that in your heart of hearts. And you know that anybody listening to the facts of your case are going to agree with you. All right, so now let's look at the procedure. What actually happens? What happens now is that after you have started your lawsuit, we now have to wait for your doctor to answer the allegations. Once the doctor has now answered the allegations, we have to notify the court that now we are ready to proceed forward with what's known as discovery, where each side gets to learn from the other what happened. Tell us what happened. Give us documents. Show us proof. Show us evidence of what you are claiming happened. So now we can evaluate it for ourselves. So now imagine if we were to go ahead and ask the judge immediately after starting your lawsuit, after the defense answers the allegations in your case, if we go ahead and say, Judge, listen, there's no dispute here. We have an excellent case and there could be no other option but to give us a verdict, give us a judgment in our favor. Immediately after starting your lawsuit and getting the answers to the allegations, can we go ahead and ask the judge for an immediate judgment in your favor? The answer is we could, but here's why it's likely not going to happen. It's likely not going to happen because the defense is going to turn around and say, hey, Judge, wait a second. We don't have any of the medical records that Mr. Oginski and his client are talking about. We have not had an opportunity to do a detailed investigation to determine whether or not what they are claiming is true. We have no idea. We've only been provided a few copies of medical records that Mr. Oginski has given to us, but we need to go ahead and get those records directly from the patient's doctors as well as the hospital where he was treated. Then we need to have our own experts review it to determine whether or not what he's claiming is true. We have no way of doing that right now, and we have no way of knowing whether or not what he's claiming is true. So at least give us the opportunity to go through the litigation process, the discovery process, to determine and answer those questions for ourselves before deciding on whether or not he's entitled to a judgment in his favor. And you know what? That's likely what will happen here. The judge will likely turn around and say, I can't tell, just from the papers alone, whether or not Oginski's client has a great case. I can't tell whether he has a good case or whether he has an excellent case. Why not? Because it's premature. It's too early in the litigation process to make a decision about whether or not you have a great case. The judge is likely going to turn to both sides and say, listen, it's too premature to give anybody a judgment at this point. Instead, go forward with the discovery phase, and at the very end, Mr. Injured Patient, you can now ask me again, once discovery is finished, for a judgment in your favor. At that point, I will reconsider that, and I will listen to this request again. So, now, to go back to the question I raised in the title of this video, if after starting the lawsuit, can you go ahead and ask the judge for a judgment in your favor? The answer is, yes, you can. But in all likelihood, you won't get it because it's too premature. The defense is at a significant disadvantage and doesn't have all the facts necessary to make an educated decision about whether or not you truly do have an excellent case. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I do realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.